Ja, also mein Name ist Sziranyi und ich komme aus der Kommission. Ich bin Mitarbeiter der...
Je viens de la commission, je suis collaborateur du département pour justice.
Faire ma présentation en langue anglaise parce que je ne me sens pas très à l'aise en
science ni en méconnaissance de langue française. Donc la suite se fera en anglais.
À l'anglais.
I'd like to talk about two things actually. The first one is where we stay with the implementation and the transposition of the directive, the 2019 directive. And you are certainly curious what we are planning to do in the context of the new project we announced, which will be most probably also a piece of legislation. But since we have Alexander Bornemann from Germany here, I would say that this is not decided, has not been decided yet. So that was in the morning session, and thank you for inviting me. It's a great pleasure to be here. It was really enriching to me. And in the morning session, somebody rightly remarked that whenever the Commission puts one foot in the door in terms of legislation, he never goes out from the room, and this is usually the practice how things work. But of course, this is not something l'art pour l'art shouldn't be, at least action. So it's the history of the EU insolvency policy. It was also mentioned. It began in the 90s. Of course, at that time, aligning the global trend, because the UNCITRAL was working on its model law at the same time when the first regulation was negotiated in 1995 in the form of a convention at that time. So really to focus on the private international law context, creating single rules of conflicts of laws and jurisdiction, and then try to ensure the circulation and cooperation between the coordination between the different legal systems. So that was the basic approach. And then, indeed, in 2015, there has been a big shift, and we just began to harmonize and try to make proposals for the approximation of national laws. But this is not, as I said, just a l'art pour l'art actions. We are sitting in our offices and thinking that, okay, we have already conflict of laws rules and private international law. Let's harmonize substantive law for member states. That's not how it works. So we have actually a big... The harmonization concept is more than 10 years, goes back more than 10 years ago when Klaus Heiner Lehne, the chairman of the jury committee in the European Parliament, prepared a report in 2011, and there has been a parliamentary resolution for promoting the recast, actually partly the revision of the insolvency regulation. But this resolution contained also a chapter on the approximation in certain areas or of certain aspects of national laws. And actually, this is the root. But of course, the real incentive or the trigger came in 2015 with the headline ambition of the Commission of the Capital Markets Union, because we realized in the consultation process with the stakeholders, and mainly, of course, with the investor side, so the banks, that there is it is in the reality, it's a genuine problem that there is this fragmentation between the national laws in terms of insolvencies, and that the outcomes of insolvencies of failed companies cannot be anticipated for investors, or very differently on a high cost. So this element posed itself as a barrier to the smooth functioning of the internal market and to the development of the single or the capital markets union. So this is the main triggering or the main motivation behind our efforts. And then the first step, as you can see, was the 2019 Directive on Restructuring and Insolvency. Somebody also very rightly and wisely in the morning stated or concluded that this has been probably because it is a specific, this contained a specific piece of legislation, meaning it's focused on targeted areas and which were considered as new to several legal systems Title 2 and Title 3, the preventive insolvency proceedings and the debt discharge proceedings. And indeed, in many member states, majority of the member states, preventive proceedings did not exist before, preventive restructurings, and in a majority there was not competitive version of personal debt discharge for entrepreneurs. So these were kind of new elements which we proposed to the legal systems and didn't really touch the sensitive areas of insolvency law. So, and indeed that was the idea behind that. Let's make this first step. Let's enter a step-by-step approach, and let's begin with a element where the political feasibility looks more beneficial than in touching or jumping into a big code or a general harmonization of insolvency laws. Yeah, now we are in the phase of transposition. You certainly know. So the original deadline was in the Directive 17 July last year. But the legislator included a possibility of opting out or on an exceptional basis by way of derogation if the member states encounters particular difficulties. Then they may request and then granted with an extension of 1 year, extension of the transposition period. And little we know at that time about the COVID, because it was, of course, before 2019, but that was the main grant for the majority of the member states. And as you may see, 23 of the member states, they notified or requested the extension. So for them, the notification deadline and the transposition deadline will expire 17 July this year. We have, of course, for the other fours, we have received official notifications, not for the others yet, but we have, as we could hear, so the other member states also made a lot of them the reforms, and we have informal, unofficial knowledge of that. So we will then begin with the transposition check. This is the usual exercise we do. I don't want to enter into internal procedural issues, but usually we do transposition check in 3 phases, and with one member states until the one phase is the preceding phase is not finished, we don't open the second one. So that means that the entire process of these 3 round of evaluations can take with the member states even years. So it's not like we immediately jump and launch infringement if we see, or consultation if we see some problems in our interpretation with the national transposition measures. But it may end up anyway in that one, and in 3 different rounds. So for the 4 who are already notified, of course, the non-communication is over, because there was a communication for all the 4 member states. And now in the process of checking the completeness, but probably results in that will come only later once we also begin with the completeness check with the other member states. The completeness meaning that we have to check whether the measures notified coincide or comply with each of the provisions or obligations put into the European legislation. And then finally, the 3rd round is the conformity, where we would like to verify whether the content of the national transposing measures is the same as we try to interpret the EU Act. Usually we use an external contractor to do the basic work, the groundwork, but of course then a very thorough quality check is followed on the basis of the comparison tables we receive. In the process of the last 2 years and still, so there are several work streams the Commission is a master of, by which we have to ensure the proper transposition. We organized in 2020 2 transposition workshops when we could discuss with member states, governmental experts, the problems or issues they may have raised. Then, of course, we have bilateral exchanges. We, in the context of DG reforms, assistance program for several member states. We provided technical assistance. These are not always financial assistance, but legal advice and consultation. And what is one really important element, and we are very proud of it, is the early warning projects. As you may see, the first one has been started by DG GROW and the European Innovation Council. It's an agency of the Commission and the SME agency. In 2016, in parallel with the proposal, when we made the proposal for the directive, and it was a very successful project with a total amount of 4.8, almost 5 million euros, which included a consortium of 15 partners from 7 member states, and which finally ended up in an EU network of over 100 experts, early warning Europe experts, who could identify and train 800 mentors or advisors for companies. These are in practice out there in the various member states, and of course still can be engaged in by companies, mainly small and medium companies in financial difficulties. This very much coincides with the obligation of member states, of course, in Article 3, which is that they have to create an early warning alert or early alert system or mechanism, have to operate, which first, on the one hand, ensures that companies in difficulties are in due time in advance warned or pre-warned if they are in financial distress. And second, that's an option, but we would like, if this would be the general scheme, that member states shall also, or may also ensure that these, after this flagging, the companies or the enterprises concerned who are in financial distress, and mainly small companies who don't have the capacity to overcome this distress without any advice, so that they can receive advice or may receive advice and mentoring from experted persons. And in this context, this early warning project fits well into this implementation or transposition of Article 3 of the directive. And on this basis, the Commission just launched, once again, DG GROW was the main service, a new project, which also lasts for 3 years, which is called the European Early Warning Europe Mentor Academy, and which tries to ensure the enhancement of the successes, including the establishment of and development of training modules for mentors and advisors. Yes, this is also one work stream in the context of the implementation of or transposition of the directive. Article 29 obliged the Commission or the EU legislator by way of an implementing act to establish a standard form for data collection by which member states then afterwards can annually notify, aggregate data on insolvency, on their insolvency proceedings, all types of data. But it is listed very thoroughly and in detailed form in the article of the directive. But in order this to be applied, we have to first adopt an implementing act, a Commission implementing regulation, and for that we can enjoy the support of a committee, a comitology group composed of the member states experts, and we have the committee. You can check the number in the Transparency Register of the European Commission, and we so far had two meetings when we began to discuss the details of the standard data collection form. What is important that when can we exploit the statistical information, which will be then, of course, in any future initiatives or projects can be used as the quantitative basis for any action. So the data collection obligation begins the first day of the next full calendar year following the adoption of the implementing act. Now we are a little bit the commission side stalled, but we hope that we can still adopt with the member states and then formally publish the implementing act this year, and that would then mean that the next year would be we have to wait a year until the data collection obligation begins with the member states. Yeah, and now I would go to the second major subject of my presentation, which is about the state of play, or some information about the preparation of the new initiative on harmonizing certain aspects of substantive insolvency proceedings. This quite complicated title is in the official work program. So this is the official title of the initiative. We are this will be the points I will address. We are but internally we just talk about Insolvency 3 as a working title. So as you may see, the last bullet down at the bottom of the page. So the Commission work program for this year envisaged or announced that they will deliver an initiative or a proposal in the third quarter of this year in autumn, which we still hope to meet this deadline. And in this context, so it was originally announced, the project in 2020, the second sub-bullet here in the new CMU Capital Markets Union Action Plan. Then we just talked about a legislative or non-legislative initiative, but after the preparation work, the state of play of the preparation, we are the communication of the CMU communication, the progress report on the Capital Markets Union Action Plan of November 2021 already went more into the detail. It said that subject to an impact assessment, so it's still subject to the results of the impact assessment, but the Commission would propose a directive. The exact scope of this directive would be subject to further discussions, and the directive proposal could be complemented by a Commission recommendation. So this is where we, I mean, in terms of the approaches, where we stand now. Yes, of course, we begin with a broad consultation process. We had an online public consultation already launched before Christmas 2020, which lasted until 16 April 2021, so almost 4 months. We received 129 answers to that. These links guide to the link of the project initiative and to the public consultation, where we will soon upload the factual document containing the summary of the results. I don't want to enter too much into the details, but just some figures. So these were what is the breakdown per industries or different branches of the respondents. You may see the almost one third of the respondents, so the relative majority of the different groups were coming from the practitioners and the professionals. These were where you are counted it. I mean, the insolvency practitioners also contributed in large number. Then we have 17% the financial sector, mainly banks. Then from a business and trade sector, almost 12%, as you may see. With regard to the public authorities, these include the governments as well, both central, regional, or local. We just have 7% the number of the answers. Amounts to 7 or less than 8%, and even from those, 1/3 were from local and regional level. So these results may not be considered as representative, at least for the public authorities' views. But never mind, we have consultations with the member states in advance, in addition to that. And this is the breakdown according to the respondents from the state of origin. You may see Germany is highly overrepresented. They were very confident, but very, very nice. And also the other big member states. And we have answers altogether from 18 member states. I won't enter in all of the exploitation, but I would be ready to share with you if you would like to see presentation just focusing on the different breakdowns and the results of the responses. I just now will show you 2 or 3 charts which you might find interesting. This is the perception by the stakeholders of how much the issue of insolvency affects the functioning of the internal market. So this is a good feedback to see whether there is really a feeling that the fragmentation of insolvency laws causes a problem, at least in a cross-border context, intra-EU. And this is the case. You may see the light blue in the different lines shows actually the supporting answer. So we have absolute majorities in the question of differences in relation to avoidance actions. I mean that stakeholders responded that they fear that this is a problem which really affects the functioning of the internal market, or the differences with regard to the asset tracing and the tracing and identification of assets belonging to the insolvency estate, but we also have quite a high number with regard to the conditions of insolvency trigger or the ranking of claims, as you may see. This is a breakdown of the answers according to how we should address or which form of action we should take. What here is the only relevant, I think that the vast majority of the respondents thought that something must be done, at least some action should be done, and only 6 responded that no measures is needed, and the other 6% said that couldn't answer or didn't answer this question. I just took this out because this may be relevant for you. Also with regard to the questions on whether we should regulate the professions more deeply compared to what we have in the 2019 Directive on the insolvency practitioners. We have a quite positive approach to that, support among stakeholders for harmonization of various aspects. We have the duties, responsibilities, and powers of the IAPs. And the second sub-question actually lists the main titles in the main headings of the relevant documents, standard setting created by standard setting parties, but which we can refer to mainly as the EBRD Insolvency Office Holders Principles, which has been just redrafted and updated recently. So when asked all of the different lines of these standards, then we have the majority or absolute majority of the respondents who said that this should be a good candidate for European action. Still, that was the public consultation, but we have other types of consultations, of course. We had a workshop with a selected group of stakeholders from various industries just 2 weeks ago, and this week we had a specific meeting with governmental experts. Yes, a real booster to our work, and our greatest help so far is our expert group, dedicated expert group, which had its origin in the previous initiative already. They helped us, I mean, at least 20 experts who were members of that group. And this has been extended in 2020 with 10 so-called Type B experts. They are experts who are representing a common interest shared by particular policy stakeholders. As you may see, these were the conditions. So this became a group of 30. We had 9 meetings until January. Actually, the group, we are very satisfied with the results. So they are really helping us, and they are still working, although we don't have any more meetings planned. Normally, the meeting reports should be published in the registry, transparency registry, under the name of the commission or the committee. So the reports are ready, but maybe we have not yet published the meeting reports, but we are in process of doing that. That's just a technical issue. Yes, also in line with the preparation, we commissioned 2 different studies, which strongly linked to which are linked to this initiative as well. Although the forum shopping study was requested or required from the Commission in the review article of the insolvency regulation, but finally it turned out that it's very much linked to this project, because one element, the second bullet point or assignment the contractor had to analyze was the different incentives for forum shopping, and in this context, a separate chapter of the final study, which has been just adopted by us, not yet published, but will be soon, looks at the fragmentation or the differences of the insolvency regimes, how much this fragmentation contributes to the incentives or serves as an incentive to forum shopping. So I think that this is also very useful to understand at least the political feasibility of different actions in the various aspects. This study is also very good in responding or confirming what has been stated in the morning by in the panel discussion, namely that that the scheme, how the circulation of the scheme of arrangements, or partly still under UK law but not exclusively, and similar purpose schemes like the preventive insolvency restructuring frameworks under national law can be ensured, how the circulation of the effects or the circulation of the decisions taken in these proceedings, because it was addressed that the insolvency regulation only accepts those which are public, fully public proceedings. This was a policy decision by the EU legislator. We had a lot of discussion when we discussed the recast, but that was the clear view, that also a kind of mistrust from from the legislator, usual mistrust to anybody who is negotiating in secret, leaving out some creditors. But we decided, I mean, the EU legislator decided that only those proceedings, insolvency proceedings, can benefit from the free circulation of the insolvency decisions and the circulation of the effects of the proceedings, who are completely public as of the beginning, and therefore accessible and to all of the potential creditors. Therefore, the insolvency regulation is not generally good for all types of preventive restructuring procedures, especially not for the not public ones, the confidential ones. And then the study analyzes very thoroughly whether these, under the current legal framework, whether the effects of these preventive frameworks can circulate or have an effect, in a direct effect in another member state on the basis of the Brussels I regulation, if there was a judicial decision, a court sanctioning, of course, at the end. Or if not, we are talking just about a private workout agreement of the parties, whether this has enforced direct effects under the Rome 1. Why not? Although both instruments apply the exception, the so-called famous bankruptcy exception, but the problem is that it's subject to interpretation whether such workouts are interpreted as belonging to insolvency law or company law, because the UK scheme of arrangement is clearly a company law scheme and not an insolvency scheme, according to the UK legislator. So the conclusion in this chapter of the study is that this requires an authoritative decision, either by a legislator or by the CEJ, the Court of Justice of the European Union in the future, to create clarity, because the case law is not is also diverse in this respect. Yeah, we have a second study as well, also at the line of the getting adopted, which directly feeds into our work on the preparation of this initiative. It's about the possibilities of asset tracing and recovery in the context of insolvency proceedings, mainly focused to the tasks and powers of insolvency practitioners. And intra-EU, what can they do? Apparently, we received information that there is a problem in practice with the application of the relevant rules of the insolvency regulation, and so this is somewhere an area where the situation could be improved. That is one of the conclusions of this study, which will be also publicly available in a short time. And I am talking too much, but it's already the last subchapter, so I will finish soon. We are now in the process of finalizing the impact assessment for that, the economic study. Of course, for that we have an external contractor and who committed to do the economic modeling according to a very trendy and very convincing econometrics. And this is the so-called system dynamics methodology, which they use. Of course, it involved, the weakness of everything is that to get the quantifiable data, of course. But where we don't have quantifiable data, we usually turn to qualitative data. And I'm afraid that at certain points we also have to do that. The situation will change once we adopt the data reporting form under the Directive, 2019 Directive, and member states begin to feed us with statistical data on their insolvency proceedings. So yeah, we will have the scrutiny board meeting in June this year. And this is just addressing some elements of the impact assessment. And this is, I don't want to enter now into the details, but happy to discuss afterwards in the break or for questions. So these are the elements or the building blocks, we call it, for the impact assessment the contractor is looking at now. I mean, which are mostly feasible or economically justifiable for any action. And behind the problems, so this is actually the drivers behind the problems. We grouped up according to two different elements or approaches. The first one is the fragmentation, differences or divergence of national member states systems as such or per se, because alone these difference generates additional costs for intra-EU cross-border investors, and the plain conclusion is that for them this is a barrier, of course, which they have to overcome, either pay on the one hand, I mean the costs of learning and familiarizing with themselves of the foreign legal system and the chances of recovering their investment, or as a second, as a lost opportunity, because then they just it works as a deterrence, and then they just don't invest to another member states, and that's where we really see the problem in the capital markets or the headline ambition. And of course, the second element we also look at, which generates problems, is the inefficiency aspect. So that they are not all of the member state systems are equally efficient, because there are clearly comparable differences between them. Of course, it's very difficult to define a standard model of defining what an efficient insolvency model is. It is almost impossible. The last exercise failed to do this was the World Bank doing business. But anyway, this was the most broader project ever done, and more consequent and methodological. But this also influences the decisions on the investments, and therefore we also see this for the impact assessment as an area of problems. Yeah. So thank you for your time and for your patience.